right, y'all. Today's final speaker, Dr. Leanne Bombach, is a senior fellow at Emory Center for the Study of Law and Religion and the brilliant organizer of this lovely online conference and excellent essay series. She'll speak on the future of religious arbitration, then bring these proceedings to a close.
Thank you so much, Alexa, for that very nice introduction. As we have heard over the course of this last hour and a half or so, religious arbitration and dispute resolution is well established here in the United States and is practiced in some form by a wide variety of religious communities. On the whole, religious arbitration and dispute resolution systems have proven remarkably adept at adjusting to the requirements of the U.S. legal system, and modern American arbitration law provides a great deal of leeway for religious communities to develop strong, faith-based systems that harmonize between religious and secular legal norms. While such systems may differ in the details, they share much in common: a desire to create an alternative to secular litigation that is not only quicker and faster, but that speaks to the specific needs of their community, a heavy emphasis on conciliation that includes not only the actual parties to a dispute, but which extends outward to promote cohesion and harmony within the wider religious community. And most importantly, a dedication to abiding by what they see as the spiritual imperative, or God's will. Looking to the future, I would like to touch on three main points that religious arbitration and dispute resolution must consider in order to keep growing and be fully accepted both within their own religious communities and by American society and our secular legal system. First, as we just heard in the last panel, religious dispute resolution forums must do a better job of recognizing and addressing power imbalances and abuse. It is impossible to resolve disputes in a way that delivers true justice and real conciliation to all the parties if the proceedings are tainted by the presence of a power imbalance or abuse. So religious dispute resolution professionals must be trained to not only look for and recognize the presence of abuse or a power imbalance, but be given the appropriate tools and resources to address them. It is also important to remember that power imbalances can exist not only between the parties, but can be embedded in the dispute resolution process and sometimes in the religious law itself. This disproportionately affects women, so we should make sure women have at least a voice in the system, or better yet, a seat at the table. No religious law or tradition is static, so we can be creative. Second, US law requires that arbitration be entered into voluntarily, and this should go double for religious arbitration. Having parties dragged, kicking and screaming, into a religious arbitral forum, as we've heard about in the Church of Scientology case, is bad on several levels. In the judicial system, it can create bad precedent, which, binding or non-binding, is bad for everyone. And in the court of public opinion, it is even worse. Which leads me to my third point. For better or for worse, all the religious communities represented here today are, to a very large extent, in this together. So while of course each has its own distinct set of beliefs and practices, it makes sense to reach across confessional lines and help each other. Not only in bad times, like when anti-Sharia laws or bad press threaten, but also in the good. To learn from each other, to share best practices, to help ensure that religious arbitration and dispute resolution is seen as a legitimate and valued part of American life.